Still on to Good Morning Nigeria on the network service of the NTA. And to kickstart our conversation on the court judgment on Section 84, subsection 12 of the Electoral Act 2022, here's our correspondent Muhammad Garba Nata'ala with the background.
Section 84, subsection 12 of the Electoral Act 2022 don't act on conventions. The section states that no political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. But even the Senate's overwhelming rejection of President Buhari's request for the section to be deleted did not put paid to the issue. Last Friday, a federal high court sitting in Umuahia, the Abia state capital, gave a judgment that nullified Section 84, subsection 12 of the Electoral Act, declaring it inconsistent with provisions in Sections 66, 107, 137, and 182 of the 1999 Constitution as amended, and ordering the Attorney General of the Federation to delete it from the Electoral Act 2022. The Office of the Attorney General of the Federation and Minister of Justice has since issued a statement that it will accordingly give effect to the court judgment in line with the dictates of the law and the spirit of the judgment. The Office of the Attorney General of the Federation and Minister of Justice was emphatic that, with the latest judgment, Section 84, subsection 12 of the Electoral Act 2022 is no longer part of the Nigerian law. Many Nigerians, especially lawyers and civil society leaders, have differed in their reactions to the court judgment. For some lawyers, it was a wrong interpretation of relevant sections of the 1999 Constitution, while others are of the view that the judgment was in order. In the ensuing debate, some persons asked if the court judgment and the reaction of the Office of the Attorney General of the Federation and Minister of Justice foreclose an appeal, and how many more sections of the Electoral Act 2022 will require judicial interpretation. Guests on Good Morning Nigeria will share their thoughts on these issues in a moment.
We have three lawyers in the House to discuss those issues raised in the backgrounder, as well as issues that my colleague and I had earlier raised at the beginning of the program. Two, of course, of our guests, our regulars on Good Morning Nigeria. Professor Usarime Osumbo, former governor of Edo State, professor of law, and also a two-term senator of the Federal Republic. Professor Osumbo, delighted to have you on Good Morning Nigeria.
It's my pleasure. Good morning.
All right. We also have with us Benasara Kogo Umar, who is a lawyer, international analyst on democracy and nation building. Benasara, delighted to have you this morning.
It's always my honor to be here to contribute in nation building.
Thank you. And also joining us via Zoom to discuss the topic is Sanusi Musa, a legal practitioner. You're welcome to Good Morning Nigeria.
Good morning, and it's a pleasure to be in the midst of the very well-versatile constitutional lawyers like Professor Osumbo and Mainasara Kogo, whom I know that you know the in and out of the Constitution. Thank you very much.
You're welcome.
I will last to them.
Okay, thank you very much, Sunusi. You know, with the advent of Zoom, following the pandemic and recourse to it, we're also sometimes struggling to get the best shot. If you don't mind, you seem to be relaxing too far. Perhaps you just sit up when we come back to you so that you have absolutely, perfect. Yeah, that's a better frame. That's a better frame that we're getting from you there. So we'll come back to you because of the conversation. Let's begin with Professor Usarime Osumbo. We're talking about Section 84, subsection 12 of the Electoral Act 2022, which has now been struck down by a court. That's the Federal High Court sitting in Umuahia. Let's have your general thoughts on this whole issue before we drill into the specifics.
Well, speaking generally, most Nigerians have been following the discussions in reaction to the decision of the court with regards to Section 84, subsection 12 of the Electoral Act. There are a number of issues that have dominated the discussions. One, people take exception or raise issues concerning the speed that it was delivered within 11 days. And that to them is something to worry about. That becomes an issue. The other is that the National Assembly was not joined as a party in the suit. Then there is also the debate as to the difference between public servants that are specifically mentioned in the Constitution as persons required to resign their employment or retire at least 30 days to the election, as to whether that is applicable to political appointees. And the issue of the order itself that the judge made directing the Honorable Attorney General of the Federation to carry out what appears to be strange kind of legislative function, as it were, of deleting a subsection of an act validly passed by the National Assembly and assented to by the President, and in fact already gazetted. That is something new. It is unprecedented, and I think it is dangerous. We'll come to that. The issue, what does section, for the benefit of the viewers, what is this really all about? Section 12, Section 84, subsection 12 of the new Electoral Act says that no political appointee at any level shall be a voter or be voted for in a convention or congress of a political party for the purpose of nominating candidates for elections. The question is this within the powers of the National Assembly to make a law of this nature? And my question is no.
Your response?
My response is no to that question, that the National Assembly does not have the right to restrict the freedom of Nigerians to participate in the democratic process outside of the limitation already imposed by the Constitution in the sections 66, 107, 137, 182. And this is very fundamental, and I want to emphasize this point, because the debates about political appointee or public servants are really not, for me, the main issue. The main issue is about the practice of democracy, the exercise of civil liberties, the exercise of freedom. Democracy gives people the freedom to participate in their governance. And you do that through participating in the electoral process, joining a party, participating at the levels of activities in the party, whether as delegate, and being able to vote during the election. Outside of the limitation that the Constitution itself has imposed on public servants, it is not within the National Assembly to impose further limitation on the rights of Nigerians to exercise their civil liberties. In this case, the right to join a political party and to participate in the process of the political party leading to election of candidates. I think it is outside of the powers of the National Assembly. And also the African Charter on Human and People's Rights mandates, provides that every citizen of every country has a right to participate in the governance of his country, either directly or through elected representatives of his choice. That is part of the Nigerian law. We have adopted it and we are under obligation to ensure that every citizen of Nigeria participates in the electoral process leading to the election of people that will govern him. And nobody has any right to take that freedom away from Nigerians in the manner that the National Assembly has done in Section 84, subsection 12.
Okay. Professor Osumbo, thank you so much for your opening comment. Let's come to Minister Kogo Umar. In the suit, the National Assembly and Attorney General of the Federation and Minister of Justice were not joined in the suit. And I believe the Section 84...
The Attorney General
Yes,
was a defendant in the
yes, a
suit.
defendant. Okay, he was a defendant. And the Section 84, subsection 12, is sort of, stamped in the brain of Nigerians for the past 1 week. Let's talk about the contradiction of the Electoral Act and how it contravenes the Constitution of the Federal Republic of Nigeria.
Well, clearly speaking, there is no contradiction whatsoever. I must commend the resilience of the National Assembly in trying to fill off a very big vacuum in our political set. The sections 66, 107, 137, and others that we are talking about are sections that are material, and there is no ambiguity whatsoever in the sections. The intendment of the Constitution, which is here for clarity, I would like to read. It says that no person shall be qualified for election into the respective offices. Then it says that unless, if he is a person employed, underline the word employed. If he's a person employed in the public service of the Federation or of any state and has not resigned, withdrawn, or retired from such employment, underline the second word, employment, employed and employment, 30 days before the date of election. This statement grammatically is very, very clear. We have three categories of public officers under our setting. We have those that are employed, means you applied, you are employed, you retire at the age of 60 or 65 or 30, 35 of service, depending on whichever comes first. The second are those elected. Those are their excellency governors, distinguished senators, honorable members, members of the state assemblies, down to local government chairmen and councillors. The third one are appointees. These appointees are clearly stated in the same constitution. Section 147, 150, 153, 154, and 171. These are people that should come and support the executives in discharging their functions in one way or the other. So the word, the Constitution is talking about those employed. Now, those elected, already they have their own limitations, tenure of 4 years in that respect. Those appointed are traditionally at the pleasure of those that appoint them. Now, the National Assembly decides to deepen democracy by sanitizing this particular area in respect of those that are appointed. In respect of those that are appointed, which, like I said earlier on, they have already been defined. Now, in this context, Section 84, subsection 12 of the Electoral Act came into being. There is nowhere in the Constitution, in the sections under reference, that appointees are being referred to. The word in there is employment, those employed. Appointees are never under employment. They are not subject of any employment. So there is no controversy whatsoever, except what we are saying now is a reflection of the democratic, characteristics drama of modern day politicians. National Assembly, I must commend them for bringing this sanity. It will go a long way. In those Senate days, you don't need to wait until even your tenure finishes. His Excellency, the President, for example, or the Governor in the case of the state, under Section 130 of the Constitution, is the chief executive officer of the government. And he is the number one public servant of the country. And provision is given to him when you take sections 147 for appointment of ministers, 150 for appointment of attorney general, 153 for statutory bodies and other three things of the Constitution. These are now given for him to help appoint them where there is dereliction in duty, unsatisfactory performance, or whatever reason whatsoever. You are at liberty periodically to be changing them. That has been the characters we have been seeing. But in a situation whereby you are living up to a time when somebody is saying, I must complete my tenure, is abnormal phenomenon. It's not in tandem with our democratic history, democratic experiences, and the constitutional stipulations. Coming back to the court judgment, it is equally abnormal for you to say the Attorney General using the word delete, should delete. Attorney General is the Attorney General of the Federation. It's not Attorney General of the Executive or Attorney General of the government. It's Attorney General of the entire Federation. And as such, he ought to stay by the side and look at the matter holistically and act in the interest of the nation, the citizenry, going by Section 14, subsection 1 that says sovereignty belongs to the people. And if sovereignty belongs to the people, the repository powers of sovereignty rest with the representatives of the people who are the legislature. The legislature, in tandem with the interests and aspirations of the people, have decided to take this onerous national responsibility of amending the Electoral Act in order to bring more robust sanity into the way we should carry out our democratic conventions and other things at the level of the parties. Therefore, my position is that the judgment has gone too excessive. Whether it is an order of mandamus, whether it is an order of whatever, I do not think the Attorney General reserved the right to go into the functions of deleting. That one is exclusively in the strict sense under sections 4, 11, sections 8 and 9 of the Constitution, resting squarely with the National Assembly and in conjunction with the respective arms, the states' houses of assembly, of which you must have 2/3 of them, which is the minimum of 24 states of the Federation. And furthermore, the Attorney General is supposed to be somebody that should stand not in respect of only one offense, but like he is a defendant in that case. There is ambivalence given by sections 230 to 304 of the Constitution of rooms for appeals, and then these appeals will go on from the Federal High Court to the Court of Appeal, down up to the Supreme Court. Until we reach such a level, we have not reached the point of finality on this matter in contention. Thank you.
Manasara Kogo, thank you very much for your exposition, but I just want some further clarification of what you have said.
Yes.
Thank you also for the distinction you made about the three sets of persons that are in the public service. You talked about, again, for purposes of our viewers, you talked about those who are employed.
Yes.
Those who will apply, go through a process,
Exactly.
and then you say that their appointment has a statutory flavor.
Exactly.
You have those who are elected,
Yes.
such as Professor Osumbo was as a senator and also as a governor.
Yes.
And he was previously also a public servant when he
previously a
lectured
distinguished senator.
at the University of Lagos and also at Lagos State University.
Yes.
Then you have those who are appointed.
Yes.
Okay. Now, at some point, he was also chairman of the Law Reform Commission. So that clarification is noted.
Yes.
But at some point in your comments, you said that the National Assembly has taken the right step in seeking to sanitize this whole process by enacting Section 84, subsection 12. There wasn't sufficient clarity, in my view, as to the point you were seeking to make. The other point about the overreach by His Lordship in ordering the Attorney General to delete, that point is clear. But what is your comment on what the National Assembly did with Section 84, subsection 12? What is your comment on that? Is it right? Because if it was right, it has been struck down now by court.
Yes, personally speaking, it is succinctly right. In fact, I expected the National Assembly's position to have gone beyond that because there is a very good tradition of manifest injustice being perpetrated in our democratic gameplay in Nigeria. You see somebody on his seat campaigning for the same seat or higher seat, using apparatus of the state, using state's money, using state's vehicles, machineries, personality, and whatever. You understand? I expected the National Assembly's position to have gone beyond limiting it to political appointees. In other words, whether you are a governor, whether you are even a National Assembly member, whosoever you are, by the time you are interested in going into second tenure or going into any position higher, sanity demands that you should step aside within the interim period. You should step aside so that you will not use the office to your disadvantage, bearing in mind
To your
Section
advantage.
15,
To your advantage.
yes, Section 15, subsection 5 of the Constitution says that the state shall is a mandatory provision in law, shall abolish all forms of corrupt practices and abuse of power. It is a clear case of abuse of power by the time you are on seat, you are using the state apparatus, state resources, and state everything. And besides, the Attorney General under Section 174, subsection 3, clearly speaking, it says that in exercising his functions, he should take into cognizance three things. The first one is the public interest. Who are the repository of the public interest? Of course, the legislature, because they are the representatives of every constituency in the federation. Then number two, they should take about the interest of justice. The interest of justice demands that inasmuch as you will be allowed to contest using the state apparatus and the rest, it is not a balanced justice with the person that is not there on that seat. So the interest of justice. And then the third one is the interest of legal process, due legal process. The due legal process demands that before you go into contemplation, whether you want to delete, whether you want to go whatever, the fundamental rights under Section 36 given for the rights to appeal up to the highest level should be given. In other words, the Attorney General, since he is a dependent, has a moral burden to appeal against that judgment immediately.
All right.
Yes.
Benasara, thank you very much. We'll also come to that point. Let's go back out to Sunusi Musa, a legal practitioner who's with us via Zoom. Yeah, we have a better frame now from you. So, as the saying goes, the floor is open for you to make your initial comments on this issue of Section 84, subsection 12, which has been struck down by a federal high court sitting in Umuahia.
Well, let me say that as a lawyer, I have no right to sit on appeal on the judgment of the High Court of Federal High Court. Whether judgment is right or wrong, I think that is now for the Court of Appeal to decide. That is if there is an appeal. You know, once a decision is reached, that is the position of the law. But as lawyers, let's discuss this issue, let's say outside the purview of the judgment. I think I have listened to Professor Sumbo and I have listened to Mainasara Ogu, and to some extent, I would say all of them are right. Yes, the National Assembly have the power to promulgate, to provide, as it did under Section 84 of the 84 September of the Constitution, on who are to be delegates of primary election of political parties. To the best of my understanding of the Constitution, no, it does not. Does the political office holders like the commissioners, special advisors be said to be part of the people that are covered by the provision of Section 68 and other sections that we talk about? I think by the plethora of authorities of the court, superior courts from Court of Appeal, starting from the case of Takori, I think it was in 2004, up to the case of Fire, I think they are not. So for me, the reasoning of the court is, declaring the provision of the Constitution is quite agreeable to me. And apart from the sections provided relied upon by the court to reach that decision, people have not been looking at Section 288 read together, which is section 2283, is the section that empowers the National Assembly to make laws with respect to primary election of political parties. And now, but then you cannot read section 228 in isolation. You must marry it with section 222 and 223. Section 222 is the section that says that only registered political parties can be able to sponsor candidates for election and also to campaign for people contesting election. And 223 says that a constitution of the political party will also be registered with the with INEC. And it says that the provision of that constitution must provide for the way and manner the executive committee of the party as well as candidates are going to be elected. So if by the provision of section 223, it means that the constitution itself has given the political parties power to decide who are qualified to vote and be voted at their convention and their congresses. Okay, by the doctrine of covering the field, that provision has covered the field in that area. So the extent of the powers of the National Assembly under section 228, to the best of my understanding, cannot extend to making legislation that has already been covered by the section 223, which empowers the political parties to make provision as how to do that. In other words, by the provision of by promulgating section 284 sub 12, indirectly, the National Assembly has gone ahead to amend the various constitutions of political parties that have been registered with INEC. I don't think the intendment of the Constitution is to give the political parties the power to now go ahead and start amending the Constitution of political parties. I don't think that is the essence of the legislation. Now, on the issue of also saying political appointees must resign for them to participate in primaries, I think that area also has been covered. If you take section 171 and other provision of the Constitution that empowers the president and the governor to appoint all those political appointees, it has specifically stated that those political appointees are on that appointment at the pleasure of the governor or the president. And it has provided a situation where they will be said to have ceased to be members, holding that office. Okay, with that in mind and the doctrine of covering the field, can the National Assembly now come and make a law to say that a person appointed by the president or by the governor will have to leave his seat contrary to the, pleasure of the governor or the president? I think that is also going outside the provision of the Constitution. So holistically, when you look at this issue, I think what we need is for all people that have been either appointed or elected to remember, before assuming duty, they have taken oath of office. And in that oath of office, they said they should do right to all manner of people. That is and they are going to uphold the provision of the Constitution. So it will not be good for people that are entrusted with the position of leadership to use that position of leadership just for them to pursue their own personal interests. Because some people think they have, the people are rivals, so they want to make a law to curtail them. That is legislative tyranny. In as much as we want to oppose and do away with the executive tyranny, then we will not now allow legislative tyranny to come in and allow legislature to make laws not for the interests of the public, but just for the interests of the people that at that time happen to be occupying the respective legislative seat of the various constituencies. And on the issue of whether the people are always saying that the judgment said that the Attorney General should delete the section, and as such, it's like it is given the Attorney General the power to, the light went off. It's like empowering the Attorney General to make legislation contrary to the provision of the Constitution. I think with all respect, we are missing the point. Look, from the day that section is declared unconstitutional, it has ceased to be a law. Okay, and the powers of the National Assembly to make laws is clearly stated in the Constitution. But then we know after that, the gazetting of the legislation is a duty of the executive, which is done through the office of the Attorney General. So if already a court of law in the exercise of its powers under Section 6 of the Constitution has now looked at the provision of a law and said this provision ought not to be part of the law, and telling the person whose duty is for him to gazette that law and make it public, say, okay, don't include this provision because we have now deleted it from part of the law. It is not the Attorney General that has deleted that provision. It is the Court of Law, and the Court of Law has the power to delete any provision that is provided in the Constitution. So I think this is my understanding. Then there are those that are saying the National Assembly has not been.
Yeah, we seem to have lost the link there, but he's back. I can hear.
Conceive the power of the Attorney General under the Constitution. Because there are a plethora of authorities that says once you sue the Attorney General, he has covered all the government agencies, including the National Assembly. So once you have an issue like this that you are challenging constitutionality of law, the necessary party is the Attorney General. Once you sue him, you don't need to join the National Assembly, you don't need to join any other person. More so, we should know that the powers to make laws is not only that of the National Assembly, it's being shared with the executive. Because when they make the law, it has to be signed by the president for it to become law. So I think these are issues that we have to look in all the ways for us to understand that how this thing works. I understand the passion of those who think that people should leave their position for them to contest election. That is a moral burden. But if we want that to be part of our laws, then let us amend the Constitution. That's my take.
Yes, Sanusi Musa, we thank you so much for your opening comment. I'm going to stay with you briefly. A lot of Nigerians have sort of come out to say, to talk about the immediate reaction of the office of the Attorney General and Minister of Justice, declaring as it stands that Section 84, subsection 12 is no longer part of the Nigerian law. What is your take on that?
Let me say that I too joined the people I found it somehow surprising that the Attorney General or the government is quick to say that it wants to comply with the law. But whether I'm surprised or not is something commendable, and we hope that the Attorney General will also be able to do same in all other laws any other pronouncement of court, because we know now there are a lot of judgment that has been given against the government and that has not been complied with. So we commend the Attorney General for his swiftness in complying with the law, and we hope, it is my prayer, that this swiftness will also be applied generally on all other court judgments that are waiting the implementation of the executive. That would be commendable if we see a situation whereby all judgments of courts are complied with swiftly as they ought to be.
Sanusi Musa, again, before we bring in Professor Osumbo and Benasara Kogo, I'm not quite clear about the import of the sections of the Constitution you cited relating to this conversation. You talked about Section 222, Section 223, Section 228, and I was wondering the relevance of those sections to this conversation, with the greatest respect. You also raised the point that by Section 84, subsection 12, as it then was before the decision of the court, the National Assembly had purported to have altered the constitutions of the political parties. Well, isn't a legislation supposed to have such an effect if a legislation is properly passed and it impinges on the articles of association, the memorandum of association, or whether constitutional parties that are registered with INEC? Those constitutions, they are, as it were, private public documents. but they will be subordinate to the piece of legislation. So I'm not quite clear what you said about that. That's one point. Second point, the news appears to be that the Attorney General is not appealing this decision because the statement that was issued shortly after the judgment was to the effect that the Attorney General's office would give immediate effect to the order by the court, which tends to foreclose any appeal.
Yes, from what the last question, the Attorney General said certainly there will be no appeal. And I don't know how those who want to appeal will go. Maybe they will go and apply and seek leave of the Court of Appeal to appeal as interested parties. Whether they will have the necessary legal backing to convince the Court of Appeal to give them leave to appeal as interested parties is something that the Court of Appeal will decide. But going back to the issue of the import of sections I cited, look, Section 222 is the section that talks about political parties, saying that no political party is allowed to, campaign for any candidate or sponsor any candidate unless it is registered by INEC. And Section 223 also said that the constitution of the political parties, which has to be registered with INEC, it must provide for a periodic election of the executive of the party, as well as in a democratic way, and it must also provide for the nomination of candidates to election in a democratic way. Now, this is clearly stated in the section. Then Section 228 empowers the National Assembly to make laws that will govern the administration of political parties, including conduct of primaries. Okay, what I'm trying to say is, if you take this section, there are sections that really we have to look at in determining the constitutionality or otherwise Section 84 sub 12. Because by Section 222 and 223, since the Constitution of the Federal Republic of Nigeria has stated what a constitution of political parties is going to contain, then any other law that the National Assembly will make with respect to the political parties cannot be up to the extent of what the Constitution of the Federal Republic of Nigeria has clearly said. It is only the Constitution of the parties that will contain such issues. In other words, the powers of the National Assembly to make laws with respect to administration of political parties does not extend to specifying how they are going to vote for their leadership, and who are to qualify to participate in the voting of the leadership, and who qualified to be elected as candidate to be nominated by a political party. This has been covered by the field has been covered by the Constitution. And the import of these sections is because when you go back to Section 1, subsection 1 and 3, which said the Constitution is supreme, and any other law that is inconsistent with the provision of the Constitution shall be void to the extent of its inconsistency. And the National Assembly, the power of the National Assembly to make legislation is derived from the Constitution which is provided by the establishment of the National Assembly under Section 4. Then you go to Section 58, I think, and 57, which provide the modes of exercising legislative power. So if you marry all this together, it is only the time that you come to realize that, to the best of my understanding, the extent of the powers of the National Assembly to make Section 84 sub 12 has been curtailed by the Constitution. These are the import of those sections with regard to this discussion. I hope I'm able to get to answer you well, because the audio was cutting actually.
Indeed, I'm in the midst of lawyers today, so it's a learning experience for me. Professor Osumbo, let's talk about the extent this judgment in Umuaha, will assist the democratic norms of Nigeria.
Well, thank you, but just allow me to make just to say that I agree with a number of points that Barrister Sanusi Musa made. One, there is he who hires the right to hire impose the right to fire. So if a minister, even we are talking of governors, president appointing ministers or commissioner, political appointees even include PAs to senators, to members of House of Assembly, to PAs of chairmen of councils. All those people were supposed to be prohibited or affected by this. And it is overreaching because you are now interfering with the employment relationship between the hirer and the political appointee, which shouldn't be. The right to hire and the right to fire should go together. The other point which he made is with respect to the role of the Attorney General. Section 287 of the Constitution provides that once a court has made a decision, it is binding on all authorities. You don't need to do anything about it anymore. So for the judge to have...
Even if an appeal is on the way?
Well, until if the appeal is completed. Okay. Until there's a different decision, this decision of the Umuahia Federal High Court is the law until it is overturned, if that is the case, on appeal. So we assume that for now, that is the law. And it is binding on every authority, every agency of government. So to ask the Attorney General to delete it is superfluous, with due respect, in my view, because it doesn't need to do anything. The other is the doctrine of covering the fields, which he mentioned. That provides that once the Constitution has touched on a subject, the National Assembly, no other legislature can legislate on it because the legislation, the Constitution covers the entire field. Likewise, if the National Assembly has passed a law on a subject matter, State House of Assembly cannot legislate on it anymore because the act of the National Assembly has covered the field. And the point I made earlier, that the Constitution has already covered the field as to people who must resign, who must relinquish their employment before the election. And there is no room left, in my view, for the National Assembly to legislate as to who can also lose his employment before he can participate in the electoral process. The Constitution has covered the field. The argument that many people are making, and this brings me to the question, what is the lesson in this judgment for our democracy? The argument that people advance is that, we need to sanitize our democratic process. We must introduce morality. It is immoral for politicians to be behaving like this. When you begin, it is safe to tread on the path of the Constitution and legality rather than on morality, because legality and morality are two separate, different things. A law may have a moral justification, but it is different from the law. The Constitution, in my view, is supreme, and the courts are under obligation to administer the law, administer justice in accordance with the law, with the Constitution, not in accordance with morality. Because once you begin to introduce morality, then you are bound to deviate and veer off course. So what I will say the lesson for our democracy is that everybody should look at, is this thing that we are doing, is this constitutional? Does it have support under the Constitution? The National Assembly, when they are making a law, must ask themselves, is this constitutional? Will what we are doing survive judicial scrutiny? Because again, the courts have a role to carry out the function of judicial review. There's what is called judicial review. The legislature can pass a law, but the judiciary has a duty and the power to review that law, which again means that the judiciary, the court, cannot stop the legislative process. You can't issue an order, National Assembly, don't legislate. Your power is judicial review. Let them finish what they are doing, then you can review it and decide whether it is constitutional or unconstitutional, null and void. But you can't stop them. Now, again, the lesson for democracy, which perhaps because of the high turnover rate in the National Assembly, this lesson probably is not known to most of the current members of the National Assembly.
Why is that?
When we first passed the Electoral Act of 2001, there were a lot of things that National Assembly thought it could do based on the draft Electoral Act that was presented by INEC for us. One of them was to prohibit civil servants from being card-carrying members of political parties. And we included it in the Electoral Act of 2001 that no civil servant shall belong to a political party. Because we felt it is not moral, it's not an issue, it doesn't speak well for the integrity of the civil service for civil servants to be card-carrying members of political parties. So we prohibited it, but it was struck down by the Supreme Court as being unconstitutional because we said the information of a political parties, the question we were dealing with was registration of political parties, that no card-carrying member of a party must be a member of a political party. But the Supreme Court said joining a political party is a question of freedom of association. And civil servants enjoy the same freedom of association like every other person. So the National Assembly was wrong to deny civil servants the right to belong to political parties. And that is the law today. That is the lesson that our democratic process has learned today. And the reasoning of the Supreme Court was that the Constitution section, which Barrister Sanusi has mentioned, 222, 221, as to registration of political parties, had already covered the field. So there was nothing left for the National Assembly to add as a requirement for the registration of political parties. There was another case also arising from the Electoral Act of 2001, which is Attorney General of Abuja State versus Attorney General of the Federation. Against two strong principles established in that case, which is a lesson for our democracy, is that apart from covering the field, it also touched on the issue of covering the field. It mentioned that the National Assembly, the power of the National Assembly to make law is not indefinite. That power can only be exercised to the extent to which it conforms with the provisions of the Constitution, either that it is in the exclusive legislative list or is empowered by any other section of the Constitution. If it cannot be defended, if an act, legislation by the National Assembly cannot be situated within an item on the exclusive legislative list or a specific section of the Constitution, that legislation will be unconstitutional. So National Assembly doesn't have power to legislate morality. Oh, let us sanitize, because that is what we tried to do by saying civil servants should not belong to political parties, by introducing morality or sanity in the process, but it was declared unconstitutional. And that is a lesson which I believe we can learn.
Well, Professor Osumbo, thank you very much. And gentlemen, thanks a lot. My colleague Jumai says that she's the only non-lawyer here, but at the end of this conversation, I'm sure she can be an associate to an extent. A number of issues on the table. Just before we take this short break, I recall the point that Professor Osumbo made about the Electoral Act 2001. The decision of the Supreme Court was in 2004, I believe.
No.
Was it 2004,
In
2002?
November 2002.
2002.
Yes.
Fantastic.
Although it was reported in 2003.
2003, fantastic. I can remember I did a piece on that in my column. But I also recall vaguely now, I probably have to revise what I wrote then, reread what I wrote then, that the Supreme Court did not, by that decision, nullify circulars and regulations of the public service. Yes, civil servants could exercise their freedom of association, but that civil servants are also still governed by the general rules, that's to say public service rules, and circulars. Because the contentious subtext then would be, all right, so military personnel, all kinds of persons, police officers, could belong to political parties. And if you belong to a political party, you also have a right of participation in the activities of the political parties. So it's a jurisprudential issue which we can pursue. But there is also a subtext of what Professor Osumbo raised with regard to some of the issues that are lingering now, that the powers of the National Assembly to make laws are not at large, they are circumscribed. That's to say, you must have it within the four corners of the Constitution to make those laws. But Professor Osumbo, I don't know whether that was a slip or maybe that was a turn of phrase, that attempting to moralize through legislation isn't within the four corners of the legislation. Is it not possible also for some persons to argue that when there is a mischief, a legislation can be made to cure a mischief, and in the rules of interpretation, by way of judicial review, the court may...
Welcome back, and our guests are seated in the studio, and Sanusi is on Zoom. Kingsley, shot a question to our guest before we went on the break, and Professor Osumbo, can you please respond to it before Minister Kogo? Response?
Yes, very quickly. My response to the question raised by Kingsley as to the effect of secular, in the civil service. Yes, even the Supreme Court judgment recognizes that you can play politics provided you don't do it to the detriment of your work. That proviso is there. But no secular can overreach the Constitution. If an act of the National Assembly that restricts the freedom of association can be declared unconstitutional, how much less a secular? So a secular, to be valid, must not deny the member of staff the freedom of association. So, and again, Section 45 of the Constitution answers these questions. That yes, there's freedom of association under Section 40 and other freedoms under the Constitution, but these are not absolute. They can be derogated from by a law which is reasonably justifiable in a democratic society. For instance, for the purpose of ensuring public defense, national security defense, public safety, public health, public order, and so forth and so on. So you can derogate from those rights under those conditions. And also for the military, is there in Section 45. It also does not invalidate the restrictions that these regimented forces, the security forces, can impose on their staff. The Constitution itself also allows that exception. So the Constitution covers whatever you need to do, that the National Assembly, as a matter of fact, really, quite frankly, cannot go beyond that for the purpose of introducing moral sanity and integrity, introduce any further restrictions or limitations. If the Constitution had intended to also require political appointees to resign, it would have included them. The fact that the Constitution didn't include them means that they were not within the contemplation of those whose freedom of association is to be restricted.
Because to be a political appointee, you must belong to a political party.
Not necessarily. There are ministers who are technocrats. They will even tell you that I'm not a politician. I'm not in this government because...
Yeah, but Prof,
Appointed by a democratic
yeah.
government.
Yeah, Prof, I'm sorry.
Yeah.
By the way, it used to be a requirement for you to be appointed, say, a commissioner, that's say a member of the State Executive Council. You had to meet certain criteria. And one of those criteria will be eligibility for election to the House of Reps, I believe.
House of Representatives for ministers.
House of Reps for ministers.
And House of Assembly for commissioners.
How do you then qualify to be a member of the House of Reps or to seek election? You have to have recourse to Section 222 of the Constitution, meaning you have to belong to a political party.
That's it.
So that some persons took that nominal membership of political parties, but in one of the alterations to the Constitution, that requirement has not been deleted to say that you must, qualify for election to the House of Reps. Otherwise, previously, it was there.
Okay.
You are right, because it became very incongruous to require INEC. It was very obvious, the anomaly with respect to appointing national commissioners or people in INEC. You require that they must fulfill the same requirements for eligibility to Senate or House of Reps, which includes being a member of a political party. And you couldn't expect INEC officials to be members of political parties. So that is. The other issue you raised.
About mischief and morality.
Yes, about mischief and morality. Again, as I mentioned, it is safe to administer justice in accordance with the law, not with accordance with morality. Judges are trained to administer justice in accordance with the law. Judges are not trained in morality because morality, it differs. Standards of morality differs from place to place, from person to person. So in order to avoid confusion, they are meant or supposed to limit themselves to the law. I will give, if I may, just another example of the danger that we may run into if we allow the National Assembly to introduce these kind of things. I cited the example of what we mistakenly did in 2001. You remember tax clearance certificate used to be a requirement. They will say, where's your tax clearance? But it's not provided for in the Constitution. So tax clearance certificate is not required. But it is morally right that if you want to be in charge as a governor, as a legislator, you should be responsible. You should perform your civic duties by paying tax. So does that therefore mean that National Assembly can legislate that you must produce tax clearance certificates? The courts have held that tax clearance certificates is not a requirement. Another one, you will recall that sometime last year, a year or so ago, a very prominent member of the National Assembly said diaspora, people in the diaspora shouldn't concern themselves with what is happening here, and they have no right to submit a petition.
And they
although it was amended, it was the damage that was going to be done was repaired by subsequently. Supposing the National Assembly also, a majority toes that line, that diaspora people shouldn't be delegates because they are not here, they don't reside here, therefore they cannot be delegates. Would that be proper? So if you allow them to impose a restriction on political appointees, be prepared for them to begin to impose other restrictions. There will be no end to it. And then, again, this issue of delete. Where you delete, you can also add. So if a judge is saying Attorney General delete, the danger is that in future, a judge will say Attorney General add this to the legislation.
That's what Sunusi Musa was saying, that once that decision is given, and Prof. You also said that there's nothing else. That's the judgment, it's notice to the whole world that provision of the Constitution has been struck down.
Minister of Popular Service.
Yes, the lessons regarding this judgment. Number one, we have to think of the originality. What brought about the need for the Electoral Act amendment under Section 84? What brought it about? We are witnessing a culture whereby you will discover His Excellency Governor as a case study will have about 3,000 to 5,000 appointees. We'll have commissioners, special assistants, senior special assistants, secretaries, undersecretaries, what have you, PAs, SAS. We'll have all gamuts of appointees. One person, his mere pronouncement says, vote for Professor this. That takes care of winning the election in whatever respects, because he has the moral burden of over 5,000 electors behind him. So the National Assembly looked at it and said, it is time for us to sanitize this phenomenon. And like Professor said, we have this lacuna that the provisions in the Constitution talks about those under employment without recourse to those under appointment. Now, those under appointments are the ones that are constituting this problem, because they are the ones that are under the teleguidance of their excellency, say, this is my directional compass. And then they follow it, and ultimately the winner emerges there. And then the National Assembly said, no. If we want democracy, it should tally with the doctrine of social justice, equality, and fair balancing. And as a result of which, every person there should go on his individual merit with a particular vote to cast, not going under a string control of somebody there. That is the reason behind the amendment in the first place. And then, jurisprudentially speaking, we should take into cognizance these two important wordings in the Constitution. Those under employment. There is nowhere, if we now say, okay, political office holders are now construed as those under employment, we are going to create serious problems in future, because they will be claiming pension, they will be claiming gratuity, they will be claiming, some of them will be claiming that since we are under employment, we are to be subjected, our tenure will be subjected to civil service or public service rules. These are some of the consequential effects of this judgment. And then another effect of it is that the Attorney General that is rushing to say that he has foreclosed the room of appeal, it means he has become Attorney General in respect of the area of his interest, not Attorney General of the Federation. If he's Attorney General of the Federation, then you have the moral burden to really appeal this judgment in the interest of the position of the National Assembly, who are the representatives of the people in all spectrum. You are supposed not even to rush and take a position that I will appeal or I will not appeal in that respect. The institution should naturally appeal against the decision. Then the third one is that if we allow this phenomenon, like we said prior to the closure of the submission of His Excellency, that you give them the power to delete, then automatically you will say add, and the decision, we are going to bring anarchy and confusion, because the National Assembly's power will be eroded upon, and it will be too bad for our polity. It will be too bad for the tiers of government. And another lesson too that we should learn is that the government then, especially the Attorney General, will now decide on which of the orders, which of the judgments to rush in complying with, and which of those to foot drag in complying with. Because there are assembly of so many judgments there laying on him. Whenever you approach, you say, we are studying the judgment. We are studying the judgment. That is a normal phrase. So why is it that he is not studying this judgment? He is rushing into appeal against it. So in the interest of justice, fair play, the Attorney General is under mandatory compulsion to appeal this judgment. Where he doesn't do that, I expect civil society groups to appeal against this judgment in the interest of the consequential negative repercussions it will have on our polity. The sections 223, 221, and other sections being quoted upon are only talking about the mechanism of operational system regarding the political party democracy in Nigeria. It has nothing to do with this issue. And very, very fundamentally, the ruling party activities is coming up this week. I believe it is very, very important. The president should think of sanitizing the system. If governors like the ones of Katsina State, the one of Kaduna State, have already issued marching order on the appointees that they should respect the Section 84 of the Electoral Act, and then clear away, since the provision as far the Constitution is talking about only those under employment, not under those under appointment. then I think the president should try the path of sanity and go about the decision, subject, however, to the Attorney General complying, appealing against it, and then seeking an order to stay the execution of that decision, so that to have a decision, a convention-free exercise as far as the ruling party is concerned. Otherwise, if these things are finally challenged, it will have another negative repercussion on the party's convention coming up this week.
Menasara Kogo, I have the impression that you are in support of Section 84, subsection 2 of the Electoral Act before it was struck down by the court. In other words, the law as passed by the National Assembly, you are in support of it.
Actually speaking, it's a revolutionary stride the National Assembly has done to fill up a lacuna. The lacuna created by only talking in respect of those under employment. Whosoever is interpreting the Constitution, I would like him to read the word by word. Those political appointees constitutes those under employment in Nigeria's public service. The answer is certainly no. Then definitely they are not subject to that. And it is the creation of that lacuna by the constitutional omission that makes the National Assembly to be patriotically disposed to bring in about this amendment.
All right, thank you very much. For the benefit of our viewers, just to reduce it to plain language, Menasara is arguing that the provision in the Constitution applies to persons who are employed in the public service. It gave three categories: those who are employed, those who are elected, those who are appointed. And that this legislation affects not the employees, but those who are appointees and, if you like, elected officials to an extent, but more essentially appointed political persons. The point has also been raised about one other issue, that the provision in the Constitution deals with participation in the general election. And that the provision of Section 84, subsection 12, before it was struck down by the court, deals with primaries. Sunusi Musa, if you're still there with us via Zoom, I would like you to take a look at this. They say the National Assembly is not purporting this for the general election. He's purporting it, well, not purporting, he had passed the law to govern primaries ultimately. Primaries ultimately, that's to say conventions and congresses, these are the lead up to primaries, and from primaries you now select your candidates to participate in the general election, which the Constitution is specific about. That's one point. Second point, so that we can maximize our time with you, and then also very briefly in terms of your response, I didn't get to read about reports in the media when this matter was on, but there are some accounts that suggest that the matter was virtually uncontested. Not that it was the undefended list, but virtually the Attorney General was said to be the sole defendant, and that the matter wasn't contested, and that even in that circumstance, His Lordship should have applied the principles of amicus curiae, considering the constitutional import of the issue. What are your thoughts, very briefly?
Let me start with that. You see, there are issues that we need to know they are discretionary in nature. What I mean by discretionary in nature is whether to invite amicus curiae or not is purely a discretionary power of a judge. That does not mean if he reach a decision, if my lord in his discretion did not deem it fit to invite other lawyers to give him opinion, that will not fault his decision, because that is a purely exercise of jurisdiction. So whether it is contested or uncontested, that which I cannot say. What I know, the Attorney General was free, and if the Attorney General went there and say he admits the claim of the claimant, then what is there for the judge is only to give judgment in favor of the claimant or the plaintiff, as they call it in the Federal High Court. So as far as I'm concerned on that issue, I think there is nothing wrong. And on the issue of whether section my lord said that applies only to the general election, I said I do agree with the submission of Mr. Mainasro Kogo on those. Because why I'm saying this, because I have read authorities of the Supreme Court and that of the Court of Appeal that says that. So even in judicial, by hierarchy of judicial pronouncement, of course, the decision of the Court of Appeal and that of the Supreme Court rank higher than that of the High Court. That I agree. But then I specifically say, like I told you, that these are issues that the National Assembly cannot come and make laws. And let me make this clear. The rationale behind it is quite commendable. And if I want to have us to have a situation whereby maybe this is our democracy, if we can amend our constitution to be having our next election 6 months after the expiration of the tenure of the current office holder, that will really help the system. Because, hello, that will really help the system, because that way we can be able to, what I mean is, then we say that after the expiration of the tenure, then everybody, then we have an interim government that is within 6 months that will be able to come up with an election that will be able to now bring a new government. But as now, the National Assembly cannot just base on morality.
Musa, we are running out of time and we have a number of tweets we have to take before we end the program. Let's go quickly to Olajide Balogun. He says the order subject to appeal has to be enforced by AG as instructed by the presiding judge based on her lordship's ruling that the said section conflicts with the Constitution of the Federal Republic of Nigeria.
Mike Anyako tweets that the haste with which the federal government applauded the judgment leaves much to be desired.
And James Palm tweets, subsection 84, section 12 was intended, section 84, subsection 12 was intended to address the trick to overwhelm other aspirants by presidents and governors by appointing many persons, hundreds, because party constitution says such are automatic delegates at primaries. None of your discussants have brought up this important point. It has been brought up actually by Mainasaro Kogo in the course of our conversation.
And we recall also that the People's Democratic Party in earlier years amended its own party constitution. At some point, it was enlarged as to the number of persons or the category of persons who could be delegates. If we were appointed, at some other point, it was streamlined so that you couldn't have the discretion of appointing hundreds of aides. The PDP tried to do that. I don't know what the state of its constitution is now. I also don't know what the state of the constitution of other political parties would be at this time. All right, do you mind?
Yeah, gentlemen. Well, you know, sorry, time has run out, but there's so much to talk about. Actually, as usual, towards the end of the program, it becomes more interesting. Professor Sareme Osumbo, former governor of Edo State, two-time senator and professor of law. Thank you so much for coming.
Thank you very much.
Good morning, Nigeria. Mainasaro Kogo Umar, a lawyer and international analyst on governance and diplomacy. Thank you so much for coming.
Thank you very much.
Sanusi Musa, a legal practitioner. Thank you so much for your input. And that's Good Morning Nigeria for today. Join us again tomorrow for another interesting edition. I am Jummai Yusuf.
And I'm Kingsley Osadolo. Do have a nice day.